session. Julie Colby will not be here because of a prearranged vacation that she had scheduled way before she was ever even thought about as a county council person. And apparently, Mr. Councilman Dunn is under the weather today. And then we got an invitation from the mayor of Baltimore to come down and participate in the parade with the Ravens at a special viewing location for elected officials only. By the way, do not bring a spouse or a guest. So that thought about that for about 3 seconds and decided no. People of Cecil County take preference over the Raven celebration. So Councilman Brumo, you ready?
Yes, I'm ready.
The first thing on our agenda this morning is to have a briefing from Larry Haslip from Miles Stockbridge regarding the rate determination case that was decided by the Public Service Commission regarding the rates for county citizens that receive town water outside of town limits. Mr. Haslip.
Thank you, President Hodge. Members of the council, good morning. Good to see you again. I have given each of you a package of materials which includes a briefing memorandum as well as a full copy of the proposed order of the Public Utility Law Judge Robert McGowan. As you alluded to, President Hodge, at 11 o'clock on Friday morning, the Public Service Commission published Judge McGowan's order in the case. This caps a four-year and several month process that began before all of you were ever in office. And so I thought it appropriate to give you some materials which document the history of the case and describe the terms of the proposed order. As I've indicated to you in your materials, this case began when a prior board of county commissioners in early November of 2008 filed a proceeding before the Maryland Public Service Commission asking the Public Service Commission to intervene and to set water rates for out-of-town users of the water system operated by the town of Northeast. And the then Board of Commissioners took that extraordinary step because under the terms of a 2002 water service agreement between the town and the county, the town was charging water rates for out-of-town users exactly 2 times the rates that it was charging for in-town users, and it refused to present those rates to the Board of Commissioners for review and approval, and it refused to justify the cost differential, and it refused to provide a full and complete accounting of the method by which it set rates in the first place. So this case, as I say, commenced in November of 2008. It was a very long and drawn out and expensive proposition. It culminated with evidentiary hearings and testimony throughout the middle of 2011 and into early 2012, finishing up with a evidentiary hearing in early May of 2012, and subsequent briefing through July of 2012, and then we've waited for about 6 months, a little more, for the commission to issue its proposed order. And if you look at the materials which I've given you, I'm going to explain to you what the issues were in the case, and to give you some idea of the complexity of matters that were at issue. First, you need to understand that the town of Northeast system serves about, in round numbers, about 4,000 customers. They're divided almost equally in terms of population between inside town and outside town. They're divided almost equally in terms of volume of usage. The town operates a fully integrated system. The evidence in the case was that the actual per unit cost to deliver service was equal. There was no justifiable differential in terms of the town's cost of service. Yet, under the town's reading of the 2002 Water Service Agreement, the town imposed, as I said, a 100% premium on the rates and charges that otherwise apply to in-town users. This resulted historically in the out-of-town users funding essentially two-thirds of the cost of two-thirds of every dollar received from the system. Over the course of 10 years or so that the Water Service Agreement had been in effect, the town had accumulated a surplus of about $8.5 million, half of which was major facilities fee, which was invested in state funds, and the other half, about $4.1 million, in operating cost surpluses. In fact, over the course of the case, that $8.1 million had grown by an extra $500,000 through additional major facilities fee increments. The record in the case, the evidence in the case, indicated that all parties were roughly in agreement about what it actually cost to operate the system. The actual operating cost was about $1.3 million in round numbers. The practical result of all that is that the operating surpluses, the fund surpluses, essentially were large enough to fund the full cost of operation of the system for about 6 years. So these were extraordinary numbers. If you turn to page 5 of the memorandum that I've provided to you, you can see where the parties differed and what all the beef was about down at the Public Service Commission. First, let me begin by saying that early on in the case, the town, this is, I believe, for fiscal year 2010, perhaps 2011, the year doesn't serve, set water rates for the inside town at $7.10 per $1,000 of usage over the 5,000 gallon minimum, which meant that the rate for out-of-town users was set at $14.20. Following the rate study, which was based on fiscal year 2012 data, which had been provided by the town, you can see on page 5 the three parties' determinations of what that per 1,000 gallon excess charge should have been. The county and the staff were roughly equivalent, $15.62, $16.27. Ms. Vermel, that's at page 5 of the...
Yes, apparently I don't have a page 5 in my book.
No,
I have the other copy.
Excuse me, ma'am, it's to your left.
Excuse me, sir, I have it, thank you.
That's the... As I was saying, the table shows the determinations of the parties on the rate per 1,000 gallons over the 5,000 minimum. The county and the staff determined that the rate for out-of-town users should be between $15.62 and $16.27. Not a great difference. The town number was $23.04. Which was almost 4 times higher than the in-town rate calculated by the town itself. As I proceed on the memo to show you, this extraordinary difference was based on the town's novel and unique conception of the rate of return that it ought to be entitled to obtain on its operating system costs, as well as its so-called invested capital. And so the difference, for example, on page 7, in the recommendations of the parties for the net revenue requirement, that is to say, the parties' determination of what it legitimately ought to cost to operate the system, were wildly different as between the county and the staff on one hand and the town on the other. The county and the staff said that the justifiable cost to run this system year in, year out was somewhere around $1.4 million. The town came in with almost $2 million, 1.979. And the difference is attributable solely to the town's estimation that it was entitled to treat this system in the same way as one would treat a return that a private utility company having stockholders would be entitled to receive. Never mind that the town of Northeast had no stockholders, had no stock, had no public debt. It was the town's position, and it was sticking to it, that it was entitled to a rate of return over 11% on its invested capital base of $8.5 million. On the theory that the town was like a privately owned utility company. Well, the Maryland Public Service Commission was having none of that. At the end of the day, the public utility law judge established a rate with a minimum, well, first off, it adopted the staff's conception that the required revenue requirement was about $1.4 million, resulting in a minimum quarterly charge of $81.37 for the first $5,000 of gallons of water used for Cecil County residents, and thereafter a rate of $16.27 for each 1,000 gallons above that. The Public Service Commission judge accepted the staff recommendation that about 48% of all of those costs were properly allocable to the county. That's actually less than the 49% which the county had argued for. The Public Service Commission judge adopted the staff's recommendation of a 2.1% rate of return rather than a 6.2% rate of return as proposed by the town. The Public Service Commission judge adopted the county's position and the town's position that the town of Northeast should not be treated as a private investor-owned utility for purposes of the rate setting. Most extraordinarily, the town's proposed recoveries for costs and expenses of the proceeding, which the county objected to and which the staff objected to, were cut by about 37%. Staff believed that the hourly rates charged by the town for its counsel and its experts was excessive, and argued to reduce the total of those charges by about 37%, because otherwise the town would be entitled to a recovery of those. In addition, the town proposed a recovery period of 3 years. Staff and the county suggested that the longer recovery period was more appropriate under the circumstances. The Public Utility utility proceedings, basically making a determination that the town's own actions had unduly prolonged the time and cost of the case. The judge concluded that there was no justification for ratepayers to shoulder expenses of this magnitude. Also, interestingly, the county and the town, county and the staff argued that the penalty provisions contained in the town's rate and charge schedule were confiscatory. There were no rational relation to the town's actual cost in dealing with people who failed to pay their water rates on a timely basis. The town charged a $100 turn-off or reconnection fee for anyone who was late in making payments, although the evidence showed that the number of actual turn-offs was very, very small in comparison to the number of charges imposed. On any given year, the number of people who would be fined this $100 was about 1,300. And the evidence indicated that a very, very small proportion of those actually resulted in a cost and expense to the town for going out and collecting the turn-offs. If memory serves, our Dr. Boland, your expert, calculated that the rate of return was something like 440% on the $13.1 thousand that was collected annually in any given year. Well, we weren't having any of this, and the staff wasn't having any of it either. And ultimately, we both persuaded the public utility law judge to redo those fees. On page 10 of your materials, I've indicated what the evidence showed. It indicated that customers who merely received a shut-off notice and then paid their full rate got charged $100 and paid $100, but in effect they paid $84 more than their situation actually cost the town of Northeast. And similarly, so then to rationalize these charges, the public utility law judge refashioned the rate and charge schedule so that henceforth staff proposed and the law judge accepted the notion that a shut-off notice would now cost customers $16. Physical shut-offs would cost customers an additional $45. And in the very, very unlikely event that the town actually went through the effort of pulling a meter, a $355 charge would be imposed.
Attorney Haislip,
Yes.
How much was it before per meter pull?
It was a flat $100 fee.
Right. So why wouldn't they be motivated then to pull the meters if there's no motivation to shut off?
I'm sorry, say that again.
If shutting it off doesn't remedy them paying the water bill, why wouldn't they pull the meter?
The evidence suggests that in practice, people who receive shut-off notices and have their, either A, receive their shut-off notices and make their payment, in effect are being charged $100 merely for the receipt of the shut-off notice, regardless of whether the shutting off occurred. The evidence also suggested that overwhelmingly, that's what most people did. For a smaller subset of those people who actually went to the process of being shut off, the evidence suggests that the actual cost to the town to shut off was still significantly less than $100. The way to understand your question, the way to understand the response to your question is that the Public Service Commission starts from the proposition that charges and rates which a utility wants to impose on customers should be rationally related to the cost of the utility, not to some sort of notion about inducing people to behave in one way or the other. So from the Commission's point of view, from the staff's point of view, from the point of view of the people who do this for a living and analyze these things, they said, when we look at the town's cost to do these various things, the number that's being charged is not rationally related.
I understand that. It's the steps taken by the town to recover recover their money. First, they would shut off the water.
That's not true. They didn't first shut off the water, they sent a late notice.
I
You sent a late notice, it had a $100 charge on it. You had to pay that late notice. If your bill was $4.95, and you were late, then you had to pay a $100 late charge.
Were you an out-of-town user?
I am an out-of-town user, but I was never late, but I know I got many phone calls from many citizens of Northeast and outside people who felt the late charge was an unfair fee, and the Public Service Commission agreed.
I asked for those names and I got just like a handful. But anyway, what I'm saying is that now the process is that you would receive the late notice, you'd have to pay $100, to not have your, water shut off. If you didn't pay, you would then if you didn't pay before, you'd have to pay $100 to have it put back on. Now, they have an extra step that they can go out and pull the meter, and it's $355, which that cost wasn't there before. So, I understand that the PSC is going to have they're gonna come up with a rate structure that they feel, is related more realistically to a process. But the outcome of all of this is that there's gonna be a $350 fee to put that meter back.
If the meter is pulled, correct?
The rate structure before, the rate, whatever, didn't include pulling the meter. So of course there wasn't any motivation to go out and pull the meter.
Well, actually, Ms. Brunel, we took the county, the staff, the public utility law judge, those people do these things for a living. They took the town at its word. The town didn't impose a $100 late fee. The town imposed a $100 reconnection fee. And in fact, the evidence showed that rarely did the town ever unconnect. So it would be as though
The thing is, look, how many other towns, follow the same practice?
No idea.
Okay.
No idea.
And then that's gonna be a question I'm gonna have for Mr. Hodge. Are we gonna go around to the other towns that provide water and police them in the same manner?
That would be a question to be taken up by the county executive and the administration. But before us today, and for the last 4 years, has been the particulars of this case. And all I was attempting to do was to explain to you what the situation was and what the public utility law judge found. And what he found was that the costs which the county was nominally imposing for meter disconnection and reconnection bore no rational relation to what the town actually was doing or what its costs actually were.
What I'm most shocked about is that after all is said and done, how much of a percent increase in out-of-town rates that they're recommending? This is the outcome. Is it 10% more?
The number goes from $14.20, which was in effect in 2010, to $16.27 today.
Right. So is that 100%, or is it, how much is that representative?
Well, the difference is, doing math in my head, the difference is about $2. So $2.
No, before it was 100% differential. What is it now?
Well, that remains to be seen because it depends upon what the town will or will not do with its in-town rates. Presently, the town's in-town rates remain as they were and have been for quite some time at $7.10 per $1,000 in excess of $5,000. The Public Service Commission does not now have, nor did it ever have, the authority to set or determine or review the rates that the jurisdiction charges for customers inside the town. And in fact, it was never the intention of the county commissioners at any time, beginning back in 2007 or 2008, it was never the intention of the county commissioners to set the rates or insist that it had a right to set the rates for in-town customers. It was always the argument of the county commissioners that the rates that the town wanted to impose on outside town customers should be rationally related to the cost of service, and should be transparently developed and should be available for review and understanding by the county. And since the county could never persuade the town of that, the county felt it had no choice but to use the tool available to it in the Public Service Commission's law to ask the Public Service Commission to come in and do an analysis. That's what the case was always about.
Council members, can we allow Mr. Hayslip to finish his presentation and then we'll ask questions?
Well, thank you, President Hocker. I'm happy to. I'm happy to.
Maybe questions can be answered by finishing your presentation.
The only other things to tell you are that the last elements of the Public Utility Company Law judge's finding is that the major facilities fee is set for all users inside as well as outside the town at $3,470. And the major facilities fee is a charge which, in all candor, the county felt was completely unjustified by the town and therefore shouldn't have been imposed at all. The Public Utility Law judge didn't agree with us. It agreed with staff and it agreed with the town that $3,470 was a rational number, so be it. There was a current connection charge of $1,750, both for inside town users as well as outside town users, which all three parties understood to be rationally related to the cost of making the connection, and the Public Utility Law judge accepted that number. So that ended the findings of the Public Utility Law judge, and those are the elements of his proposed order. It's called a proposed order for the simple reason that it's an interim order which is subject to appeal or objection by any of the parties to the proceeding. And any one of the three parties, staff, town, county, could file an appeal as to all or part of those findings. That appeal, if it was going to be filed, would have to be filed by March the 5th of this year. If no appeal was filed by March of the 5th, then the proposed order would become a final order and would be binding upon the town. If any party files an appeal within that 30-day period, then that particular party has an additional 10 days within which to file the written basis for that appeal. And then the responding parties have an additional 20 days to file written responses as to why the appeal should fail. At that point, either the Public Utility Law judge will reconsider the matter, or one or more members of the Public Service Commission itself will take up the matter and make a ruling. At that point, that ruling becomes a final ruling, and if anyone still had the stomach to proceed, then a further appeal would be taken or could be taken to the circuit court, first for Baltimore City, and then ultimately on appeal to the Court of Special Appeals or the Court of Appeals of Maryland. So that's the procedural posture of this. I haven't been asked by the administration, but if I were, my recommendation would be that this order is all that the county had right to expect or more, that it is a very, very favorable order for the county, that the county ought to be well pleased with it, and that the county ought to hold out the hope that the town will understand that the likelihood of any successful appeal is extraordinarily remote, and that the matter and no reasonable justification would exist or hope would exist, that the order would be changed. It simply remains for me to try to put this in context and sort of to explain what the proceeding means and what the result means in practical terms. The practical impact of this ruling is that the way in which the town had been proceeding in respect of the county and the county citizens of its system is for all practical purposes at an end. It supersedes and makes moot the way in which the town had dealt with out-of-town customers under the water service. The Public Service Commission has exercised its subject matter expertise and its jurisdiction and has set the rate for out-of-town water customers based on cost of service principles consistently applied and based on the evidence before it. And that evidence base, by the way, was the facts and figures as they existed in the fiscal year 2012 budget of the town. By its nature, that order provides a maximum amount beyond which the town cannot deal with the county citizens. As time and costs change and circumstances change, to the extent that the town believes that an adjustment is required, the town will need to go to the Public Service Commission and justify any attempt to change those rates as they relate to out-of-town customers. When it does so, the county will have an opportunity to intervene and to review and approve the town's proposed numbers. And most importantly, from this point forward, the burden of proof before the Public Service Commission will be on the party attempting to make the change. So that the town will have to consider the cost and expense of going to the Public Service Commission to make a change. So that's the legal leg. By law, the Public Service Commission is only entitled to set rates for interjurisdictional water service. That is to say, the rate that the town would charge to out-of-town customers. So it is not permitted to review, approve, set, comment on the rates that the town is now charging or would charge in the future to its in-town customers. It could be argued that the county's activity here has not succeeded in eliminating the rate disparity between the town and the outside customers. But I want to say, as I said earlier to Councilman Vermel's earlier comment, the county never argued the rates between the in-town and the outside customers should be exactly equal, or that it knew at the outset of the case what the rate or rates should be. Instead, it insisted that the rate or rates, whatever they were, should be rates that were based on a transparent analysis of the actual financial data based on cost of service principles. We said that in writing multiple times, beginning at the very beginning of this case. It was always the position of the then county commissioners. The county commissioners were not experts in this field, that they were not going to presume to simply throw a dart at a dartboard and say what the rate should be. They simply knew intuitively that it couldn't possibly be the case that the fair rate for out-of-town customers would always be exactly 100% of the rate set inside the county. But in the near term, and certainly in the long run, it's possible to predict that the rates for in-town customers will have to tend to approach the rates which have now been set for out-of-town customers, and which will in the future be set forth by the PSC. Why do I say that? Well, because the detailed testimony in this case establishes the following facts. Facts, by the way, which we did not know when the case began, and which we could not have known without going through the discovery process. First, the system operates as a unified whole. There is no determinable cost differential between the cost to provide a gallon of water to somebody living inside the town as opposed to outside the town. Next, we know that almost exactly half of the users of the system are inside the town, and almost exactly half of the users live outside the town. We know that under the current regime, on the other hand, for every $6 of income to the system, $4 of income were being paid by out-of-town users, and $2 were being paid by in-town users. In effect, the Public Service Commission has established, based on the 2012 figures, what the total cost to run the system should be. And it has then said, we're going to set a rate and charge schedule which is calculated so that if the total cost to run the system is $6, the out-of-town users will pay $3. Well, presently, as I said, the out-of-town users are paying $4 and the in-town users are paying $2. This is an arithmetical proposition. The PSC has determined that henceforth the out-of-town users will pay $3 of that $6 charge. And it will be up to the town to figure out how it covers the remaining $3. There are, in the interim, in the near term, two ways in which the town can do this. Number one, it can rationalize the service charges that it imposes on in-town users. It can make them pay the remaining $3. Or, for political or other reasons, it can keep the rate for in-town users at the $2 that it presently is. That means that each and every year it will run an operating deficit for that $1. In point of fact, the testimony under oath of County Administrator Ms. Melissa Cook McKenzie was, Town Administrator Melissa Cook McKenzie was, that for the fiscal year ending in 2012, I believe, that's to say that was the testimony in May of 2012, the facility ran an operating deficit of about $500,000, $510,000, and that the town dipped into the major facility fee reserve to the tune of that amount in order to make the books balance. The plain fact of the matter is that the evidence in this case indicated that since the commencement of the case and the time when the testimony was taken, the cost to operate the town system has risen dramatically. Dr. Boland, your expert, determined that the cost expense of the Severn Trent operating and maintenance contract had risen 67% for fiscal years FY11 and FY12. Dr. Boland also figured out that the depreciation and amortization charges jumped remarkably in FY11 and FY12 due in major part to the fact that the rolling mill road system for the system had come online and now was fully able to be depreciated. So the little secret here is that this system is, from a financial point of view, not the same system that it was in 2008 when this case commenced and when those earlier $7.10, $14.20 rates were in effect. It's apples and oranges. So in order to fund the cost of this system, it just simply costs more money to run it. The good thing from the county's point of view is that from here on out, the process of determining how much is a process that will take place with reference to cost of service principles, which are established and reviewed on a very transparent basis by professionals who are employed by the state to look at these things, people who make it their business to understand these things. So, to repeat and to sum up, the system charges to be borne by the outside town users have now been set. They're fixed. They're based on cost of service principles, consistently applied. These rates reflect the fair cost to these users to run this system. As for the in-town users, it is up to the town to determine how they will treat those individuals in respect of rates, fees, and charges. And at least for the short term, they can either raise those rates to reflect the true cost to those customers to provide that service, or for the interim at least, they can continue to burn the invested surpluses that the system now has, at least until those funds run out. So that's the sum and substance, and I'm happy to take any questions that any of you have.
Thank you, Mr. Hayslip. Does the council members have any additional questions?
Yes. How much was it, how much did it cost us in legal fees, from the expert, to, get this cost of service principles that we go by?
We started work on this matter at the request of the county back in 2007, and most all of our work was finished, I hope, through the end of 2012. And over that 5-year period, we billed the county $376,000 and change in fees. I don't have the exact numbers for all of the experts that were hired, but it is somewhere between $50,000 and $70,000. We discounted our fees to the county, unbidden, I might add, by $68,000. We also went to your experts, and unbidden, I might add, and asked them to give rather significant discounts to the county, because frankly, we were astounded at the costs that were being racked up in this case, and felt that the county had right to be upset with the cost and expenses for this matter. It's therefore, I think, a matter of some satisfaction to me as your counsel to see the Public Service Commission take the extraordinary step, use the extraordinary language which it did in this case regarding the behavior of the town in the matter. You should know that your expert, Dr. Boland, didn't just perform one rate study. Do you know that he performed 2 full, complete rate studies? And do you know why? Because when the case was practically finished in December of 2011, the town at the 11th hour found a brand new expert with a completely novel theory and produced a brand new set of financial data, sort of throwing a ringer, if you will, which caused us to have to stop the whole case, ask the Public Service Commission judge to step back and allow us to understand this, analyze it, regurgitate it. We had to hire an additional expert, who, by the way, we hired at essentially our cost, because the then county commissioners refused to pick up that cost. And we thought it was critical to the county's success. So we had over 100 data requests. I repeat, over 100 data requests. It's extraordinary. It's just extraordinary that it should have taken, that this sort of rear guard action should have been fought in the way that it was by the county. Mr. Wine, sitting to my left, can tell you, and Mr. Flanagan was sitting by my side in early 2007, and he can well remember sitting in a meeting with Mayor McKnight and Ms. Cook McKenzie, when at the request and instruction of the county commissioners, we went to the town and we said, look, don't put us to this. Let's together split the cost. Let's go hire an expert. Just show us the data. Show us how you come up with the numbers. We'll let the chips fall where they may. We just want to know what the numbers are. We just want to be able to look our constituents in the face and say that the numbers you're charging are rational and related to the cost to run the system.
Is this an accepted practice by other towns?
Sure, done all the time across the country. Done all the time. Couldn't get there. Could not get there.
You're surprised that once the attorneys were involved, the costs escalated?
Quite the contrary. That's not some new insight. I'm surprised and stunned that it was allowed to get there. And those decisions were not the decisions of your council, nor necessarily the council for the town. But I regret that it was not possible for the town to accept the offer and repeated offers. And as I say, there were people in this room who were there at the time and who can tell you that offers were made in good faith to settle this matter cheaply, expeditiously, fairly, and for whatever reason, could not get there from you. So, I hope that's a full and complete answer for you.
Okay, so the cost in attorney fees and experts were close to $500,000. How much was it for the town of Northeast?
We don't have that information. We just simply have I don't have it handy, but
it's got to be close to $500,000 as well.
I just don't know. I suppose I could do the math and take the number and then gross it up by an additional 37%. It's a big number.
The increase in rates outside the town now, is there going to be another increase to tack on the attorney fees that
No.
they're allowed to recoup?
No.
Okay.
That's baked into that cake.
Okay.
And let me make one final point, if I may. This is not my opinion. This is not my guesstimate. You can look it up. It is in the transcript. I can show you the place in the transcript of the testimony if you like. Melissa Cook McKenzie testified under oath that rates were not increased during the pendency of this case for the out-of-town users, precisely because the case was pending. And Melissa Cook McKenzie testified under oath that the delta for the end of FY 2012, I believe, was $510,000. And Melissa Cook McKenzie testified that but for the imposition of this case, that number would have been made up in increasing rates. Well, you do the math. If every $2 that comes into the system would have been paid by the out-of-town users, then 2/3 of $510,000 is $34,000, $340,000. And $340,000 is roughly that fee I pointed out to you. And that was just in that 1 year. In addition, if you look at the proposal that was made by the town before the Public Service Commission, $122 for the first 5,000, $115 for the first 5,000 gallons quarterly, plus $23.07 for each $1,000 thereafter. And you compare that number with what the Public Service Commission has established. The annual savings in each and every year going forward for the out-of-town customers is something on the order of $600,000.
Do you anticipate any time in the future that the differential will go below 100%?
Oh yes, for the reason I told you. Because I can do arithmetic. I know that if the total cost is 6, and the Public Service Commission says you can only collect 3 from the out-of-town, that means the in-town have to find another 3 somewhere. And presently, the in-town are actually paying 2 out of that 3. And presently, the remaining 1 is made up by dipping into the town's invested funds. That bucket of invested funds will run out if that behavior continues. It cannot continue indefinitely. How long is indefinitely? I don't know. But to answer your question, I feel pretty certain that if that's the financial model, then at some point in the future, the bucket will run out. And 6 will still need to be found in each and every year, and only 3 will come from the out-of-towners. So somebody's gonna have to come up with the remaining 3. And when that happens, the answer to your question will be yes. That over time, one would hope from the period of point of view of rationality sooner rather than later, but over time, it will be the case that more or less equality will prevail between all in-town and out-of-town users to the system, for the simple reason that the facts indicate that the cost to run the system is exactly the same whether you live inside the line or outside the line. So fairness and financial common sense dictates that the cost to be imposed should be the same inside the line and outside the line.
Councilman McCarthy, do you have any questions?
Hold on just a second, let me double check. Could you tell me why the county took a position that there was a zero return on equity proposal, and the expert that we had was involved in the Cumberland case that we referred to? Why would we take that position, and the commission disagree with that?
Yes, sure. That's a bit of inside baseball, but I'm happy to explain it to you. Dr. Boland's position, which your council completely subscribes to, believes that the Public Utility Company's article means exactly what it says. That is to say, that a utility company should be entitled to a rate of return on assets of the utility that are used and useful. And there's a corollary to that, which is that a public utility company, and I see Mr. D'Annunzio in the room, and he represents an investor-owned utility, but the point is the same for investor-owned utilities as it is for public utilities. Utility companies should not get a rate of return on assets that they didn't pay for. In other words, for example, in the Artesian case, when we made a distribution of the county's wastewater system to Artesian, the price was set at the book value of those assets, not higher, not lower. Why did we do that? We did it because the higher the cost of the asset to the utility, the more the utility would be entitled to earn in rate, which means the higher the rates the customers would be required to pay. So to repeat, a utility should not be entitled to a rate of return on an asset that it got for free. And the evidence in this case shows that the system has had at the time $8.5 million of do-re-mi in the bank, cash. Where did it get it, and what does it represent? The evidence in this case is pretty incontrovertible, that all that cash essentially came from the out-of-town users as essentially a gift to the system, owned by the in-town users. So Dr. Boland's insight was, if I were to take a mile's worth of pipe sitting outside the town, and I were to give that pipe to the town of Northeast, it couldn't include that pipe in its rate base because it never paid anything for the pipe. It was a free contribution. That's black letter utility law. That you could look it up in any book. That's the rule. Dr. Boland's point of view is there's also black letter utility law that when people give cash in lieu of stuff as a gift, that cash in the system shouldn't be entitled to a rate of return. So Dr. Boland's point was, if you look at if you analyze where all the cash came from, the whole $8.5 million represents pure surplus. And we pointed out to the Public Service Commission judge, by reference to Supreme Court cases in other states, the Commission Commission's own precedent, that the Commission has previously, and other people who have looked at this have taken the position that yes, you should treat cash in the same way that you treat bricks and sticks and pipes and stuff. Well, as so often happens, this public utility law judge essentially split the baby. The concept that had been propounded by the town was so completely out in left field that nobody but the town was having any parts of that. But on the other hand, the public utility company law judge thought that the position raised by Dr. Bolton, although theoretically sensible, worked an unfair result to the town. Now, practically speaking, does it make a lot of difference? No, it doesn't. Our rate of return was something in the order of 700 or 70 basis points, 3/4 percentage point. The staff recommended, and the town and the judge ultimately accepted about 2.1%. So you're talking about a 1.5 difference. In the scheme of things, it's not a big deal, and it made a negligible impact on rate.
I just have two more questions.
Yes, ma'am.
Could you tell me why it took so long for the PSC to come back with this opinion? I thought it was due back in November.
I wish I knew. I don't think it's being unfair to the Public Service Commission to say that efficiency is not one of its strong suits. Let me give you another example. I didn't get into the weeds on this, but you remember I told you that this case commenced in the fall of 2008, and we didn't start producing testimony until the fall of 2011. Why that gap? Well, very early on in the case, the public utility law judge set the scheduling order and issues on burden of proof, who'd have to come forward and make the case first, then who'd have a chance to respond and so forth. We strongly objected to the procedural posture. It put too much of the burden on the county, and we thought that was completely unfair. We, after all, are not in the utility business, the town is. We thought it was more appropriate that the town be forced affirmatively to come to the commission and justify what it was doing. And then if we had a problem with it, we'd talk about that problem. If it looked fine to us, we could stop there.
No,
Public utility company law judge was having none of that. And so we filed an objection to that and appealed. Do you know, we waited for over a year. We waited for 13 months for the commission to actually rule on our objection. It never did. So finally we said, the heck with this. Let's just proceed with the case. So answer your question is, the Public Service Commission runs at its own speed, and it justifies its speed to no one.
Well, the other, I guess it's more of a comment, for us to have generated over $1 million in attorney fees to challenge the town of Northeast, to come up with a rate structure to justify its costs for the out-of-town users. We need to think about, are we also going to request the same of the other towns? Why would we have went after Northeast and not Rising Sun or other towns that have their own water companies? I think that's the outcome still. I hear what you're saying, that you anticipate the rates are going to go down outside of town, but the reality is right now they're recommending rates that are actually higher.
I don't think I said that the rates are going to go down for outside of town. I don't see how that would be possible since the costs to run the system have increased so dramatically.
And I hear what you're saying. You said the basis of this was never to challenge the outside of town rates.
No, it was. The basis of this was to establish what the outside town rates would be based on cost of service principles.
Well, I guess it's the way you look at it. I mean, if now they're recommending a higher rate, what?
Well, excuse me, there is a difference, and it's a profound one, and I may not have, obviously I didn't express myself clearly enough. we said from the very beginning, the county commissioners said from the very beginning, that they were county commissioners and they weren't water rate experts. They said that they could read the town's rate and charge schedule. They knew what the numbers were, but they had no way of understanding whether that was a fair number or an unfair number or a ridiculously unfair number.
And that takes you back to why aren't we also following through with the other town centers?
We may. That's a decision that we'll have to talk about. That's a future decision that others will have to make that decision. I thank you for coming, Mr. Hayslip. I'd just like to make a comment that there was a previous board of commissioners that decided that it was in the best interest of the citizens of Cecil County that lived outside the town to move forward with this rate case. The question was, what is the fair and justifiable rates that those citizens of Cecil County outside town limits should be paying for their water? I think everyone can agree that just double the town rates was an arbitrary rate that no one knew for sure whether it was justifiable or not. No one anticipated the length of the case. No one anticipated the cost of the case, but I'm going to say that I'm going to quote right out of the decision that the town, and this is in quotations, flaunting of the basic rules, end of quotations, of the utility proceedings actually drove up the cost and the length of this case. And it's unfortunate that we, previous Board of Commissioners, current Board of Commissioners, and others, particularly the town, was not able to work this out amongst ourselves without the Public Service Commission getting involved. But now, going forward, which is I think the most important part of this, is that we now have a basis to move forward. We now have determined the cost and the percentages and everything that needs to be done to move this rate determination for future increases, so that we'll be fair and equitable for all those citizens of Cecil County that live outside the town northeast that receive town water. So this is all water over the dam as far as the cost and what's going on here. A lot of lessons were learned. I'm sure that not everyone's happy about everything, and it never is the case. But I do believe that we are in a place now that we can move forward with fair and justifiable rates for all those that do receive the water. So thank you for coming, Larry, and hopefully this will be the end of this, and any further discussion about other rates charged by other towns will be a discussion for another day, and if you'd like to bring it up, we'll talk about it.
Well, no, I'm not. I've already stated my concerns of how this case originated, and I believe it was a few days after you were elected, that the letter was sent down to the PSC. And it was the previous board in 2008, I believe, when they were first elected. So, I've asked for the lists of the people that actually had complained about the outside of town rates, and it was basically a handful of names that I had received. We really need to think twice when we undertake an action like this.
Agreed.
Make sure it's not for personal reasons.
The next item on our agenda is approval of the minutes for January 29th of 2013, at our work session. I have a motion to approve the minutes, please.
Make a motion to approve the minutes with one change on page 3. Third paragraph from the bottom, President Hodge advised the public that an effort was made by the General Assembly to repeal the sustainable growth. It says legislation and ag preservation. It should be the Sustainable Growth and Preservation Act.
Okay, there's been a motion to approve. Was there a second to the motion to approve? You've made a motion to approve it with amendment. Is there a second to the motion to approve the minutes with an amendment? I'll make a motion to approve the minutes.
You'll second?
Second. Second, I'm sorry. Is there any discussion? All those in favor of approving the meeting minutes with the amendment, say aye.
Aye.
Aye. Any opposed?
I abstain. It's vacant.
You weren't there.
That's correct.
Okay, then there was one abstention, because he was not at the meeting. Okay, we have meeting minutes on January 29th of 2013 for the closed session. You have a motion to approve the meeting minutes for the closed session, please.
Motion to approve.
I will second that also. Is there any discussion? All those in favor of approving the meeting minutes for the closed session of January 29th of 2013, signify by saying aye.
Aye.
Those opposed? You will abstain from that also. Next item on our agenda is a presentation from the Upper Shore Regional Council provided by Doris Mason. Is she still here? Oh, there she is. Doris, you have the floor.
Okay, thank you so much, Commissioner Hyde. Good morning, everybody. I thought I would come in and just share with you a few updates from what's been happening with the Upper Shore Regional Council. I think most of you probably already know that the Upper Shore Regional Council was created in October of 2003. I joined the organization approximately a year ago, January 23rd of 2012. And since that time, the council has been up to a few things, and I just thought I would come in and share some of those things with you this morning. As you probably know, the Upper Shore Regional Council represents Kent Union and Cecil counties, and we are a part of a team of 5 councils across the state. Each council represents 3 rural counties in the state. There's the Tri-County Council for Southern Maryland, and you can just guess which counties they represent. Then there's Tri-County Council for Western Maryland, and then there are 3 councils on the Eastern Shore. There's the Lower Shore, which is Somerset, Worcester, and Wacomico, and then there's the Mid Shore, which is Talbot, Caroline, and Dorchester counties. So I regularly interact with my peers across the state. They've assisted me with becoming acclimated to the role as executive director for the council. And again, just want to share with you a few things. Our mission is to foster regional planning and development for our 3 counties, and literally to afford an opportunity for local governments, state government, federal government partners to come together, identify priority issues across our region, team with private sector as well, and do planning that will literally enhance the quality of life for our residents across the region. So that's sort of the council and who we are in a nutshell. Wanted to share with you, I guess, some key things that we have been doing over the past year. Already highlighted there who we are. That's our mission. Again, did highlight the key components of that. As a partner here in Cecil, the council, I sit on the Economic Development Commission, work real closely with all of the partners in your EDC office. I do the same thing in the other 2 counties, Kent and Queen Anne's. Partner regularly with your county council, county executive, many other partners in the county, and would like to increase that. Our executive board is made up of some of your county council members, as well as county council members in the other 2 counties. Going to just share with you a few things that we have continued. Many of you probably remember my predecessor, John Dillman, and I have continued a few of his projects as well as picked up some new projects. You probably know that one of our primary funders is the Maryland Department of Business and Economic Development, and each of the counties contribute. We are working to develop hopefully some private resources as well. But currently, past year, we've been working on our Upper Shore Harvest directory. We've been working to update that directory. And in a nutshell, the directory is a compilation of our ag-based businesses across the county and across the region. We're augmenting that via a partnership with Washington College to not only update a listing of our ag-based businesses in the region, but to also add some supportive online marketing, supportive services to the ag-based businesses, as well as some other resources. We have presently in our office 3 interns from Washington College. We work with the director of the GIS department there, Stuart Bruce. We did pull in a MERDAP grant to support the project, and the project is well underway. We're at the stage now where we are authenticating our data with the businesses, and next month we are going to do our first go live of the website, mid-March. That's due March 15th. So we're right on target with our deadlines and time frames. Do we have internet here in the, I'm connected, aren't I? Let's see if I am. I'm gonna also share with you another ag-based project that we're working on, our Shore Vines project. And as you probably know, the Shore Vines project was initially focused on supporting our wineries across the region. There's lots of how-to videos there for anyone who wants to start a new winery. Some of our vineyard owners in the region have added winery components. And so, in addition to all of the vineyard support services that have been a part of the site for a long time, we added a winery how-to component this year. We added some training videos by some local and statewide viticulturists. And so that whole link there is new to the site, and you feel free to explore that if you're interested. But we were happy to be able to add that component. We've had the vineyard management component there for some time, but again, we were happy to be able to add the winery component. We are exploring adding a distillery component as sort of the next up and coming type of ag-based business across our region. We've seen a few emerge already. We're also exploring and sort of brainstorming whether or not we would like to add a niche marketing component, supportive component there, for those who are interested in developing some of the niche marketing, some of the ag-based niche businesses. We have many of those that are emerging right now across the region. So we're looking at that. We just want to support that component of business growth in our region. Just one facet of support that we'd like to continue to offer and increase. Let me see if I can get back here. Another thing that we did this year, and I won't click there, but we did do a remote oyster setting outreach project during 2012. As many of you know, there are a couple of initiatives, but there's a statewide initiative to replenish the oysters in the bay. The remote oyster setting was an outreach project that we did in conjunction with the University of Maryland and with DBED, with Marbidco as a funding resource and a few other funding resources. We pulled that together, helped organize it and host it, and had several of our local watermen attended. We had several educators there. We had, again, several financiers there. Did generate some local interest across the region. Some of our watermen who were interested in doing the business of the remote oyster setting, because it is indeed a profitable business and proves so to a couple of businesses across the region. Two main facets to that, I guess. One is to cultivate the oysters and reset them in the bay. The other is to cultivate the oysters in order to sell them to local restaurants and others for profit. We've had a few successes again across the region. Like to see a few more. That was just an outreach project again that we did in conjunction with the University of Maryland. Many of you probably know there in Y Mills, there's a Y Research Center there, and so we partnered with that center, with the center there in Cambridge, had some educators come from all across the state and share in a one-day setting there in the spring. So that was, we thought, pretty successful. But again, we'd like to do more with that project. If you go to our Pinterest site, you'll be able to see a little bit about what happened during that particular day and just some of the resources that we were able to share there. I think that's